Thank you. Yes, so we're streaming live now. Good morning, everyone. This is just for those of you who are listening, this is May 20th, and it's bargaining between Portland Public School District and the Portland Association of Teachers for the substitute educator contract. So good morning, everyone. And I have, as we just said, I sent over a counter proposal to the district's proposed ground rules, which I can screen share now, I think.
That sounds good. John, can we just try to cover a concept for an agenda today? I know
sure,
we have limited
absolutely.
time, and so totally agree. We'd love to hear your comments and responses on the ground rules. So I think that's a great place to start. Second, we did make it through your comprehensive proposal that you sent, and we've prepared at least initial thoughts, responses, questions to that. We don't have any specific counters today, but we would like to walk through your proposal. I mean counter proposals to what you have actually proposed in your comprehensive proposal is what I mean.
Gotcha.
So we'd like to go through the document again and have some discussion on that, if that sounds okay.
That's fine.
And then from there, I think we check in on time, and we have proposals that are teed up and ready to go. We would just need a couple minutes to polish them and push send. So hopefully we can get to that today. If not, we might end with us pushing send once we're offline.
I was just going to say, if we could possibly do that offline, if necessary, that would be okay with us too. Of course, it's up to you if you'd like to present and share at the same moment. But yeah, the more progress we can make, the better.
Great.
Okay. Let's see. So here we are. Can you see that, everyone?
Yes.
Great. Okay. As you know from our discussions last session, there were no changes that we had of any kind until number 12. And number 12 had to do with the idea of communications. And so after I gave this some thought, I completely understand where you're coming from. As we mentioned in bargaining, we're not looking to have, some sort of negotiations in the press either. But we know that there are times when, either we're contacted or, as I mentioned, and feel the need to respond to it. So what we've suggested as a counter is that neither party will initiate communications with the news media or issue a press release until after mediation and declaration of impasse. And then I put, just to get across that idea, the parties recognize the importance of working together to reach final agreement, and therefore will consider joint communications to the press prior to any individual media release. The reason what we struck was, or comment to the general public on the status of negotiations, including social networking. It's, as you know, it's common for associations to meet with parent groups, with other teacher groups, with everything else, to share ideas and to talk about what's taking place, particularly with locals outside of the PAT, who I believe would be part of the general public. And we can't put ourselves in a situation where we can't share that information unless we jointly do it. So it's not that we are looking to create a stir, but we also don't want to inadvertently put ourselves in a situation where we're violating the ground rules. So that's the reason for these our strike-throughs that we have. And that's the only change that we had for the ground rules.
Okay, great. Okay, I understand the change you made. I'd like to chat with my team about it before we lock it in and sign.
Sure.
I do have one other discussion point related to the ground rules, but process-wise, I would suggest that we just keep moving. I don't think we need to caucus right now over that, but
I don't think so either.
I'd like to discuss your changes with my team and then let you know. Hopefully we can get it signed. Other item related to the ground rules are the rule that we're at least conceptually agreeing to around in-person bargaining. And we've obviously had a big development since our last session with new CDC guidance, OSHA guidance, and state guidance around masks and vaccinations and everything. So I know my team is interested in exploring in-person bargaining with
Sure.
that development in mind. I know that we have these dates set for virtual bargaining under the process we're doing right now through the end of the school year. I think it makes sense to keep those sessions scheduled under the same process and procedure we're using now. But just flagging that as we work through these next few sessions, we would like to explore how to get back in person, perhaps once school's out.
I look, yep, that'd be great.
I think that we had already included in the ground rules that we would want both sides to assure that their respective teams are fully vaccinated and past the waiting period. So we'd have to tackle that on our own ends and then talk through logistics of it. But I'm glad to hear you're open to it, and let's figure out how to make that work as we move through here.
Okay, and I really, frankly, I haven't asked the team members if they've all vaccinated or not. But we will certainly have that and be able to discuss this, as you say, when we move forward.
Okay, and again, I think the ground rules cover this and will allow us to get them signed and put them aside, and then we'll have that discussion as we move through these next few sessions.
Agreed. So
great, thanks. Well, as soon as we take a break, we'll take a look and get back to you. But unless you have anything else, I'll jump in and start running through your proposal and our comments on that proposal, if that sounds okay.
Sure, that'd be great.
And logistically, does everyone have that in front of them, or is that something that I should share my screen as I move through? What do you prefer there?
Do you have written comments to written counter type things?
No,
if that's the case, we don't have that.
No, nothing written. This is discussion, questions, comments.
Gotcha. Well, then why don't we give us a moment and we'll open our, I didn't have it open and ready to go, but I can have that in a second.
So John, you're going to screen share?
Well, since this is, Chris, since you'll be presenting, why don't, I would suggest you screen share for that, but.
I can do that. If you'll just give me a moment, I'll tee that up.
Sure.
One moment, please.
Sounds good. And I am going to turn my camera off so you don't have to deal with me eating. I've got to teach without a break. So.
Thank you for doing this, Greg.
I may do the same thing for the same reason at some point.
Perfectly fine. And gentlemen, if you're doing that, if you would just mute your mute your computers also, and then turn them back on to be able to ask questions or clarifying moments.
What, you want to listen to me chewing?
I wouldn't even mind seeing you chewing.
Can everyone see the document?
Yes, thank you.
And only the document?
Yes.
Yes.
Okay. So starting with Article 1 on recognition, we're not able to agree to this proposed change at this time. We have a fill rate problem. We're working through options and potential solutions to that. We can't agree to this at this time. The only specific language comment I have on it is that the first sentence, I don't know that this first sentence is in controversy, and it seems to be covered by the prior sentence. I don't think there's any doubt that we employ subs and that the district or that the association represents subs. So we're still thinking through this draft language, and then, as I've said, we can't agree to the second sentence at this time.
So are you saying you want to hold on to the right to subcontract substitute teacher work?
We're not willing to agree to waive that right, which I think is the inverse of what you're saying.
Yeah, okay.
So in Article 2, association rights, when you have the provision for including email, you know, if you feel that's necessary to include in the contract, we'd be open to doing that. It is covered under PECPA now. It's, you know, we refer
Sure.
to House Bill 2016, you know, it
Yep.
says that. So it's a statement of the law. So if it's something you feel is important to include, we can do it, but our position is it's covered by the law. I don't know how much it's necessary to dump PECPA provisions in our contract, but that's not something that we're entirely opposed to.
Gotcha. And we agree. And it's just whenever we can get clarity for future groups coming in and to avoid any sort of misunderstanding, we try and do that. But okay, I mean, I hear what you're saying. Yes, it is definitively covered by the law. So
Okay, I'm moving on to these proposals in Article 2, association rights in Section B. So on the proposal that we consider the substitute teachers and email list groups separate from other employee groups, that's currently happening. My understanding is that Nicole has made that change and that they are. So again, I don't know that this is a particular problem that needs solved through contract language. And if there's an issue that we're not aware of, we'd like to discuss it. On the second piece around the district shall work to not send emails that are intended for those who work at BESC. Again, my understanding is that we have taken steps through that email separation to try to not do that. I mean, my understanding is we've worked through this and it shouldn't be a continuing problem. And frankly, it seems like something that I'm not sure we would want to include in contract language. I mean, that something might happen, and we kind of hate creating potential violations over what are really minimal issues. Like if we accidentally send the sub something that's meant to go to BESC, we'd rather not have a contractual requirement around that.
right, and that's the reason why we tried to say shall work. We understand that it is not. I mean, obviously, if the district's making a good faith effort to do that, which we could have expressed it that way also, I assume. If mistakes happen, mistakes happen. But yeah, if to be honest with you, from the members of the team, they felt this was an important thing to include because they thought my impression is that it's still going on. But if it's been corrected, it's been an odd year. So who knows? Maybe it has been corrected and people just haven't realized it. That we're certainly, as you say, if it's a problem that's solved, it's something that's solved. It's the reason why we included it, because we didn't realize it had been.
Okay. On C, the district shall email the UniServe consultant copies of all district communications to groups of educators. Again, this is an item that we're not open to including in the contract at this time. I mean, you have a team of employees who will be receiving these, and we feel that it's more appropriately their role to forward those sorts of communications on to you. Again, we communicate with employee groups regularly. We're hesitant to create potential violations in the contract when, you know, our expectation would be that your team within the sub bargaining unit would be on the lookout for those communications and providing them to you. And this, again, this is limited to communications. Obviously, if there's changes or things that we need to give you notice of,
Sure.
we will provide notice. But this is
It wasn't indicated that you weren't doing that. I hear your feeling about it.
Yeah, and you know, we're looking at the regular unit here as well. We don't do this practice for the regular unit of forwarding all employee communications automatically onto the UniServe reps. So we're trying to keep consistency there as well.
I understand your position. The working conditions for both groups are distinctly different in the way in which they're able to interact with each other and interact with the PAT office at times. So this was an attempt to keep open communications and not to have things miss. But I hear you don't want to do it. So, okay, you don't want to do it. That's not that we're dropping it, just I understand your position.
Understood. Okay, so I'm moving on to subsection I here, which is fine. We're willing to agree to that, and we'll make sure to include that in any proposal we send back to you to make it clear that we're agreeing to that. They're happening is our understanding. We want them to happen.
Sure.
This is a more accurate description of how it's happening, so we agree. If I missed some small typo type corrections as I skim through this, you can either let me know or we'll circle back to them later.
Yeah, actually, we have a long, thank you. They're from, I guess, just 1,000,001 different versions of this contract over the years. There are typos throughout this. We have a list of all of them, and we just figured at the end of the contract, when we're all done this, we can sit down and say, here's what we think are the typos and correct it from there.
Yeah,
but that's if you'd rather do it another way, that's okay with us too.
That sounds great. We were planning in our first set of proposals to include a housekeeping provision that explains some of the generic changes we want to make. That's a great one to include: typos, grammatical changes. We're going to be asking to move all gender references to gender neutral references.
I think we're considering the same thing. So
change the term substitute teachers, all of that's all over the place. Make it substitute educator consistent throughout. And we'll propose that to you, and it's an easy thing for us to agree to. And one of the final versions should capture all those. Okay, on F, employee discipline. We understand the interest and the reason that you're bringing this up and proposing it. However, we think that it's drafted too broadly. We think that it's drafted too vaguely. And we think that other aspects of the contract would already cover this and result in us being in the same outcome, is the short version of what our issues are with this and why we're not willing to agree to it at this time. So the term difficult class situation, that's very much open to interpretation. The descriptor effective help is very much open to interpretation. And then we can't agree to, manage the situation successfully is broad and open to interpretation. And we're just not going to be in a position that we would waive a right to discipline based on that language. What I will say in response is these substitute educators are covered by a just cause standard. There's a robust body of law built around what that means. There's arbitrators apply just cause in various ways. There's still the traditional 7 steps. John, I know you're well versed in that. We're seeing some arbitrators that are moving towards more condensed, reasonable person considering all circumstances type tests. Mm-hmm. And we think that all of these factors that you're bringing out and addressing here would be part of the just cause analysis, both on the part of the district. If it's investigating this issue, they obviously investigate and we make disciplinary decisions based upon that just cause standard. And if we have a dispute over it, the arbitrator would be applying it too. So things like if the substitute educator asked for help, what the district's response was, what were the unique circumstances present in that classroom at that time, those would all be factors potential evidence or potential factors that go into the just cause analysis. So that's a summary of our response on this and why we aren't willing to agree to it at this time.
Gotcha. Just for your clarity, we've had just cause provision in the contract for a long while. There have been disciplinary cases where we've had hearings, and the district has actually moved in some moments over the years to say, well, it was your responsibility to do it. Yep, we could possibly take it to arbitration over a letter, but the point of the contract is to clarify the responsibility of both parties, and leaving it up to a third party arbitrator, we think is a poor way to go about doing it. So again, like the other situation, your position is clear, but we can't accept it. We will be bringing this back again in another form. If you want clarity on the language, we'll be happy to do that. We'll explain what difficult class situation may be, and we'll explain some version of effective help.
Yeah, and John, I'm not suggesting that we boot every dispute to an arbitrator. That's not what we're suggesting at all. At any disciplinary action, the district's going to have just cause in mind. If it's a serious disciplinary action, you're going to be there representing them, or your counterparts are going to be there representing them, and making these challenges. And these are all the factors that we'll be looking at in that unique situation. Was it a difficult class situation? Did you ask for help? What was the district's response in asking for help? What steps did you take? Was that effective or not? Was it successful or not? I mean, those are all the things that would be involved in that kind of a discussion. So yeah, we'll welcome clarity, but those are the reasons we can't agree to it at this time.
Okay.
Okay, I'm moving on to Article 7, substitute rights, non-discrimination. And thank you for taking a stab at this. We obviously want to update this too. We want to make sure it's consistent with the regular units description and with other units description. The only thing I want to flag is the description of the identity, activities, or status of the substitute educator, spouse, or partner. The term activities seems a little broad. I mean, that could cover anything. I mean, I don't want to throw out silly hypothetical examples, but I think there are situations
Oh, I
where,
see what I get what you're, yeah. Okay.
And status, I know what you mean by status, I think, obviously but status is pretty broad. And I mean, identity, I think I understand where you're at there, just based solely on their identity. And we agree with you that association with a protected class entitles a person to protection under Oregon law. We agree with that. We want to come up with a way to say this that accurately captures the status of the law, is I think where we're at. So this is one that you can expect a counter from us on. Totally agree, we need to update this. We will take a stab at updating it to be consistent with law and consistent with our other non-discrimination provisions, if that sounds fair to you.
Sure.
Can I just say something?
Yes.
It seems like all this needs is a couple of adjectives: legal activities and protected status.
Yes, I agree. And that's what you're reading my mind on our counter. It'll be
Right.
Some form of a reference to applicable law. Yeah. Yeah, you caught the duh there. That's a good one. We're going to try to do a clean sweep of the contract on all that, as we discussed.
Right.
Academic freedom. We're in Article 7D. We'd like to discuss this a little further and ask a little more specifically around what the intent and interests are in this proposal. In our discussions and careful review of the existing language, it seems that the folks that inserted this language in this substitute educator contract were very specific limit the academic freedom to when a substitute educator is engaging in creating lesson plans. And it seems like you're asking to include comments made in delivering prepared lesson plans. And we just would like a little more background on the proposed change so we can help understand the proposal more.
Oh, now that's,
If you
I didn't
want,
mean
or
to be silly.
later, now, later.
That's
Yeah,
not-
we're asking
okay.
for. We're asking
sure.
for
So
clarity
what
and-
we're trying to, what we're trying to avoid is an educator saying something in an attempt to explain a topic in a lesson plan prepared by the absent educator. The student asks a question, the substitute educator gives a clarifying example. Someone goes home and tells a parent, Mr. Berkey said that blank was such and such the case. Well, we don't want to have somebody who's disciplined for trying to make clear language, make clear ideas in a lesson plan. Remember that the substitute educator has limited experience with the students in many cases, not in all, but in many cases, very limited relationships with them. And students can take things differently when a substitute educator says them than their regular classroom educator. All this is really meant to do is say, look, an educator attempting to make clear an idea has the same right to express an idea that might be controversial to some kid in a way, as long as it's an attempt in a neutral way. It's not an attempt to, give a biased example or anything else, because that would be covered by the other contract also.
So what about the distinction between the way that the language is originally written, which looks to apply to when the substitute educator is creating the content, versus the proposal you're making, which seems to cover existing?
Right. 99.9% of the time, a substitute educator has an emergency generic lesson plan. But there are times when they're in a long-term substitute situation where they do create their own lesson plans for each class. And in those circumstances, they have, as they're creating the lesson, they have academic freedom in creating the lesson to cover the required topics from the district that the other teachers have. The differentiation is when they come into the class, they've had very little time to prepare it. They're asked a question on the spot, and they're trying to make that clear. Obviously, they need the freedom and the capacity to be able to make those things clear without being held to some sort of idea that, well, you shouldn't have expressed that concept because that may have been taken differently by student A than student B. This is not to say that offensive or patently rude or any other concept is acceptable to us. It's that I think the example that Stephen gave was, trying to expend constitutional rights and say, well, this is related to, the Second Amendment, and having a student be offended because of their position on the Second Amendment. Well, it's not meant to be controversial. It's meant to be clarifying. So
can we, I'm struggling to have that particular example ring true for me in this language. Is there another example, or is there a way to elaborate that example?
Let me try. I was at a meeting the other day where the icebreaker question was about what we're planning to do on the 4th of July. And several educators of color were offended that the question was about celebrating the 4th of July. We live in very fraught times, and people are liable to take offense at things that the person speaking thinks are innocuous.
Another perspective on this is.
I'm sorry, Stephen. I really don't mean to interrupt. I'll ask you to hold your thought. I just want to follow up on Greg. So,
yeah.
And Greg, I want to make sure I'm tracking. You're saying it from the perspective that, correct me if I'm wrong, please, but are you saying that you're saying it from the perspective that a student might receive what a substitute educator intends to be an innocuous comment in a way that they take to be offensive, and that could result in problems for the substitute educator?
Yes.
Okay, thank you. I just wanted to make sure I understand that. So I appreciate you sharing that. And I'm sorry I interrupted you, Stephen, but I hope you still have your thought.
Yes. So I think part of the origin of our request to change this is that the existing language makes it seem as if academic freedom is something that springs into existence only with a teacher, a substitute educator who is responsible for lesson plans. Now, I've gone in and taught, of course, math, which is what I mostly do, and it's hard to see the context for much academic freedom issues there, one way or another. But I've also been called on to teach where the subject was constitutional law, and having some background in that, I wasn't there to express my opinion, but opinions leak through. And even though I was teaching a lesson plan that was already prepared for me, it's hard to see why that fact that the lesson was already, that there was not a lack of lesson plans, that I could not express what I need to express. And again, I'm not referring to proselytizing, just discussion tends to have opinions.
Is there another example of what you think? How could the current language land a substitute educator in hot water, and how would this fix the issue? I guess that's what I'm trying to understand. And the Second Amendment issue just didn't really.
Just let me speak schematically. So if a discipline issue is brought for something a substitute teacher said, typically because a student or a parent complained, and the teacher says, but academic freedom should protect me, and you can make up your own examples, and the district says, oh, but you were teaching a lesson plan that was prepared for you, so there can be no issue of academic freedom. You can't cite that. That's what the old provisions seem to say.
Okay, that's helpful. I appreciate that.
That is exactly the issue, right?
Okay. My team, any other questions or discussion that you'd like to add? All right, we appreciate that input, and we'll keep considering this one. Okay, on to keys. This is in Article, where are we? 7. J, keys. So on the first paragraph proposal in J, we understand the issue. We have current contract language that addresses it with the proviso that it's whenever possible. Our position is that additional language is not required to fix this issue. We think this is an issue we should just fix. And what we'd like to propose is that we take care of this, that we try to take affirmative steps right now outside of contract, or we're telling you in contract negotiations, but we want to fix this now. We want to try to follow up with you about how we fixed it, and hopefully we can avoid having to have this language in the contract. The reason is there may be situations where it's not possible to get keys to every single substitute educator. I mean, if there's a large number of substitute educators in the building that day, if someone walks off with a set of keys and we haven't had a chance to do it yet, again, we're looking to not add language to the contract that can end up in future disputes. We are looking to solve problems. Message heard loud and clear here. We've already added this issue to the principal monthly checklist to ensure that they are starting to take steps right now to address it. And we're going to take additional steps that we can follow up on how to fix this problem. We understand the issue.
Okay. We did think that that certainly the language that was there, the existing J was an attempt to address it. It's been a long time coming to hear. I mean, it's not that Nicole and her office is not doing lots of things. It's that we know that she is because we've seen her attempt to accomplish this task. This language was an attempt to just make it clear to the building administrators that no, there is an absolute requirement for them to try and address this. If the district's willing to say, we hold our principals responsible for this, and we will in fact deal with it as part of their professional responsibility, we're fine with that.
Okay, and we're happy to follow up with you. Again, we'd like to not have this in the contract. We'd like to follow up with you on what we've done and how we're doing it, and then hopefully we can move forward.
Okay.
K is going to be a similar response, except that we absolutely understand the issue. We're willing to do this. We're willing to address it. We're willing to fix it immediately. What we can do right now is add it to the start of school checklist to ensure that the folks that are handing the substitute educators their materials are aware of this. Again, we would prefer to not have this be contract language. We prefer to have it be a process and procedural fix that we implement immediately in order to fix the problem.
Okay. I mean this sincerely, thank you. I know that it's not as though, and again, please, I know it's hard to say these things and not have them land awkwardly for members of your team. This has appeared in one form or another in the last maybe 3 contract negotiations. It's been something that's come up in a jillion meetings with the district, one way or another with substitutes. Nicole, I know, has made efforts to do this. It does not always translate to the buildings, not through lack of Nicole's office trying. This is, again, one of those ones where we understand the issue of keys. It may not be possible to do this, but a sincere good faith effort is, if we take what you say on face value. K is something we've asked for, I've been with them for 10 years. I think we've asked for this for 10 years. We know that there have been attempts and it hasn't happened. So it is something that will be hard for us to let go on this one. In terms of including the language, not in terms of your desire to correct the problem as a district or anything else. Just it's many tries, many different ways, and many attempts to get this in the contract because of the fact that it doesn't happen.
Okay. We do see L as applying here. Subsection L that includes a process that we think is meant to address these sorts of issues at this level of issues that you need resolved in order to do your job. Our position is L covers these types of issues and it should be addressed there. We understand your position. If you include it, if you continue to include it, we'll continue discussing whether to include the language or not. At this point, our position is we'd rather not. We'd just rather solve the problem.
Understood. Yeah.
As a guy who shows up so often to sites and be told, you don't need that, or sorry, we don't have a bathroom key for you, or sorry, we can't let you into the office space that your teacher would use, even though somebody else is using the classroom during your prep, right? I want to strongly insist on this only because of the number of times out of working 165 days in the 2019-2020 school year, I was told something that I think is unacceptable.
Yeah, I would agree it's important for us, those two.
Okay, understood. Okay, on to Article 8, substitute lists, subsection F. The first sentence, we're a little unclear what you're driving at or what the interest is that you're asking for us to, what the interest is in this first sentence. mean, if a substitute educator loses their license, we can't employ them as a substitute educator. That's not called out specifically in Article 6. That's the concern we had with the first
That was not
sentence.
our intention, I'm sure.
Okay. Okay. I'm being nitpicky at this point, but if Article 6 provides the way to remove an educator from a list, I'm not sure why we need to say here, you have to follow Article 6 to remove an educator from the list, but that's me being picky. On the second sentence, no substitute educator shall be removed from the list for failing to work the required number of days during the pandemic. We're open to this concept. We need to think through how we're going to incorporate it in conjunction with our other proposals. I can tell you now, we would prefer it take the form of an MOU that's very specific to the unique situation we're dealing with, rather than including it in the body of the contract. But this is something that we're open to, and we will get back to you on.
And I just wanted to copy the contract so I could look back and make sure I was correct when I said Article 6. I think the intention of Article 6 was to say there isn't an evaluation procedure for substitute educators, and it's possible for an educator to actually not be disciplined. We didn't want to have someone just because, you know, you work the days and you weren't disciplined, but thanks, but no thanks. That's the only reason why we had that was the purpose of it. In other words, we didn't, if the intention is that since Article 6 is discipline, and that of course is a reason, obviously, and we would never stand against that for removing an educator from the list. We also didn't want to have other reasons invented for not having a person on the list. That's the sole purpose of that first sentence. And if it didn't strike in a sound or meaningful way, I just want to make sure our intention was clear. It is odd that they're educators without an evaluation system, but it's also that case because I'm not sure how the evaluation system would work or who would do the evaluating, and, you know.
I've said it to you before, John, in other circumstances. Part of the reason I like working with this group is it's very unique. It creates unique challenges that we need to think through and address.
Right.
Here we have an employed, per diem is the closest analogy that I can think of in the medical field, workforce, who can elect when to work, where to work, if they want to work or not. They're covered under a CBA, and that presents a number of unique challenges, including the one that you just raised, that there's not a current evaluation process. Yeah, I mean, there's other tools that we'd have to use if there are those sorts of concerns. And it presents a lot of challenges. I'll just leave it at that. And
yeah, I hear you loud and clear, and I agree.
Okay, well, we're going to have to continue thinking through the reference to Article 6 with that context in mind. It just begs the question of, well, what if we do have serious performance issues that maybe aren't disciplinary? What do we do? So that's something we're going to have to think through.
Yeah, it's been handled. We do need to think through it, and we tried. I was not happy with the outcome of the last one. The district tried to address this, and we allowed the district to write the language on the discipline section to incorporate sort of some of that idea, even though it's not discipline, to sort of address it as a sort of discipline-ish type circumstance with the idea of a building restriction. Or a letter of expectation or those types of things. And so, yeah, I mean, I agree with you. This is something we should probably think through.
Yeah, I mean, it's frankly not realistic to provide performance evaluations for substitute educators. If they're teaching all over the district, who's going to be the clearinghouse for that feedback and information?
Yep.
Or if they only work 3 days, or let's use a better example. If they only work 25 days, how's that? Yeah, challenges galore.
Yeah.
I'm glad to understand that you're specifically referencing the performance-based separation piece of this, evaluations, and let us think about that further, and we'll have more comments or discussions.
Yeah.
Okay, I'm on to Article 9 in work hours. So we'll go through each, but I do have a broad statement in response to a number of these provisions in Article 9. On one hand, it seems clear that the substitute educators are happy with a compensation system based on either full day worked or half day worked. On the other hand, we're seeing a number of proposals where substitute educators are asking to be compensated in certain circumstances as an hourly employee. And there are advantages and disadvantages to both of those types of systems. But I can share that trying to combine those two systems will create a number of administrative headaches on the district's part. Time tracking, who tracks the time, how do they track the time, et cetera. So I'll leave that broad comment at that, and then try to work through and respond to some of the specifics. On the assignments lasting up to, correct me if I'm wrong, but this seems to be, I mean, what I see in other contracts is call-in pay, right? If you're other contracts in other industries, right? If you report to work, you get paid a certain amount because you were inconvenienced with having to report to work, even if you were released away. And it seems like that's what you're getting at here. And if I'm wrong, correct me. It seems like there are other provisions as well that are making the same sort of, or advancing the same sort of goal. Is that right?
This B was an attempt to make clear what is already working. If the substitute, I guess if you would like to put it in those terms, that's fine. I mean, if the substitute shows up and they work a 1 hour shift or a 3 hour and 45-minute shift, they're paid as a half day. And by the way, 1 hour, I picked that randomly. The illogical extreme would be 1 minute to 3 hours and 45 minutes would be the half day. No one comes in for a minute, obviously, but you get the idea. So since that's the case, and there's been some confusion that came up a few times, although the confusion has never been, it's always been enforced that that's a half day. We said, okay, fine, let's just make it clear. If you're in for an educator for a 2 hour shift, you're not paid on some sort of hourly basis, you're paid as a half day. And the district actually agrees with that. It's been supporting that forever. Way longer than I've been here, as far as I know.
Correct me if I'm wrong, but I thought that was actually enshrined in Oregon state law that substitute teachers have to be paid for a half day.
Greg, I don't know. I'd have to check, and it may be the case.
Yeah, I had that impression. I don't know where I got it from, but I had that impression as well.
I appreciate that comment.
I'm also on the board of the Oregon Substitute Teachers Association, and I believe that most of my colleagues could tell me the statute.
Okay. All right, that clarity helps on B. That'll help us evaluate your proposal. On C, and your additional comments, we appreciate that. We'll look into those as well. C is a similar, it's a similar comment. It's just that we're still thinking through administrative and budgetary impacts on operating under both systems, of both a block-based pay system and an hourly based pay system and how that would work. So we can't agree to it right now. It's something we're trying to understand from a budgetary and administrative impact.
Sure.
Sorry, not impact, lens on what those impacts would be on us.
And I maybe just to help clarity on this one, we understand yes, I suppose time tracking might be an issue for the district. I can hear that. The reason why we have that is that when a substitute accepts a position, whether it's full day or half day, it has a start and end time. And that's fine. That's in fact as it should be. We're not suggesting anything else. But if a substitute is suddenly asked to work beyond that end time, particularly if it's beyond what would be the half day rate, clearly if it's beyond the half day rate, it becomes the full day rate. That's already currently the example. So if it's a 3 hour and 45-minute assignment and the person stays for 4 hours, they become a full day substitute. And that's always been the case. As I say, when I arrived, that is the system that was in place. But what happens when it's a 7 hour and 30-minute assignment and they're asked to stay for 8 hours? That's all. And those times are posted by the district in the job that they take.
Okay, I understand what you're saying. I know during our internal discussions, we had concerns too around, we understand your intent of your proposals to say required. If an administrator comes in and says, I need you to stay late, we're short on this, you got to stay and work late, that you're saying compensate them hourly. We understand that proposal. We do have some concerns around what's going to be interpreted as required, or when might folks claim pay with it, even if it's not required, and what are the checks on that to make sure that we're doing our diligence before spending these sorts of public funds and having boundaries on that. I mean, these are the things that we're struggling with and discussing as we're evaluating this proposal. And those are the reasons that I'm saying now we can't agree to this, because we're still trying to understand how that would work and what the impacts would be.
I get that then. Thank you.
So I'm on to D here. The first sentence, we're having difficulty understanding the unique circumstances when this might come up, and how, I mean, I think that giving your proposal the benefit of the doubt, we can understand if someone's in a long-term assignment and they need the prep time in order to be able to do the long-term assignment. And if they're asked to do additional work, that could cause that educator issues, just like if a regular educator has their prep time interrupted. So I think we're clear, we at least understand your intent from that perspective, but we're also having a hard time understanding why we would agree to put something in the contract that if it's a single day job, if the prep period occurs at the end of the day, if the teacher requesting the substitute has not left any instructions or tasks for the substitute educator to perform during that time, under your proposal, it would be a free pass to just sit and wait out the clock. And I know I'm using a stark example here, but sometimes those stark examples help us work through language issues. So we're struggling with that distinction.
I'd like to add one more thing to the mix. And it turns out that teachers accept the school day as an alternative to the rules that specify a 30-minute lunch and 2 15-minute breaks. And so the way the language is currently written, many substitute teachers don't realize that they are legally entitled to a half an hour out of that prep period as their breaks, because they've accepted the teacher's schedule in lieu of labor regulations that require 2 15-minute breaks.
All right, Greg, thanks for adding that context too.
And let me also add, I know you, Chris, you gave that example as an extreme example, and I want to agree that it's an extreme example. And when I've been in the situation of being asked for extra service when it's at the end of the day. And most of the times, of course, that means there's nothing more to do, clean the erasers kind of thing could be conceivable. I'm always willing to do it at the end of the day. That's a very distinct situation, and it could be that this needs a carve out in that direction.
Well, it's also true that some more than rarely a substitute's day is very stressful. And, if you've just been through 3 stressful blocks, that rest at the end of the day is welcome. And you don't, we're being paid to cover the teacher's schedule, and, to go through all the stress that we are undergoing and then have to go more that we shouldn't have to undergo. That's part of what this is all about.
I
think
suppose it's fair to mention that I'm no longer on the substitute list of any of the districts that told me I had to cover prep periods.
I mean, and I think Mark's summary of it, I think, gets right to the heart of it. When a substitute accepts a position, they're substituting for a given educator, which is what we have in E. And I mean, I know, without being extreme in any examples, it is not, it is the norm for some students in each class to challenge one way or another the substitute's authority in the classroom. It's a nature of being a kid. It's just the way things are. It's probably been that way since, Socrates. So, it's an incredibly stressful position, outrageously difficult. And it's very difficult, as Mark suggests, to say, you've just been through that, now go do one more. So.
Yeah, I think we're driving to the heart of our dispute here with Mark's comment and your follow-ups, John. That's the issues that we're having. Is no one's doubting in any way that it's a stressful job. We fully acknowledge that. We're charged with being stewards of public funds. We have constituents that we have to explain how we expend those funds. The comparison with regular educators, I mean, they're expected to work during that. If they have a prep at the end of the day, it's because they're prepping for what's coming next. And same for a substitute educator in a long-term job that's covering it. But we're going to have a hard time explaining to explaining to administrators that they get to recuperate during that period of time.
Just an insertion here. You use the term long-term job, which probably has a technical meaning of more than 10 days. And of course, many 3-day jobs, for example, have preparation for the next day. Let's keep that possibility in mind.
And it's also true that some subs make a habit of coming in earlier than the 15 minutes before school so that they can see what's going on. So you're sort of getting something there too. But you're paying us to cover for the regular teacher.
Yep.
And that means covering for the
Following
regular
the
teacher. And if we have covered for the regular teacher, you have got your money's worth.
Yep. And that's our position.
Yeah, we understand your position, and we've got a disagreement here. So that.
And in fact, could I ask Nicole, isn't it the substitute office's position that substitutes are entitled to their prep periods?
I would say we say that the substitute gets the teacher's schedule, but we also encourage substitutes to step in and help at schools when there's unfilled jobs, if they're able to. So yes, they get the teacher's schedule, but we also recommend that substitutes help out where they can.
And that is, thank you, Nicole. Thank you very much, because that is what we were suggesting in the, for the same way in which regular classroom teachers do. regular classroom teachers do the same thing, fill in when there are, it would clearly be an unsafe condition for a student to be uncovered. So, but that's, thank you for your comment, and we get where both sides stand, I think.
Yeah, and just be aware that what's coloring this as well is the very distinct and acute sub shortage we have right now, and the scenarios that we're running through our minds where where a building is understaffed, where other educators or administrators are stepping in to fill voids, and then some of these examples that are coming out, they cause us concern around that. We're trying to find ways to fix a problem. So agree, John. I think we've made our respective positions known. We'll continue evaluating this, and
I just want to make one last comment, Chris. Perhaps part of the problem with the fill rate is substitutes avoid buildings where they get asked to cover classes.
And remember, the proposal does say except in case of emergency. So we're not saying you can't order subs to be covering in case of emergencies, but I think subs are often asked to cover in other cases, and that's what I think we find improper.
Let me also add one thing that we haven't even discussed. It's the subtext of this draft, paragraph D, that only an administrator can decide it's an emergency, as opposed to school secretaries. Now, school secretary certainly can get an order from an administrator and convey that order. That's fine, but it really should be at the authority level of an administrator.
To declare an emergency and assign to work during the prep?
That's what he's saying, yes.
Yeah.
Yeah, I think I have almost always agreed to help the school out if they ask for coverage. And I say, sure, I'll be happy to cover half the period. I need my break, and that has always worked out fine for me. And so I think Stephen is right. Pretty much the only time I've ever turned down the request to fill in is either if I have important work to do or if a secretary has tried to order me, because I don't get ordered by secretaries.
Yeah.
Okay, well, we appreciate the discussion, and we'll discuss some of the points you've made. The last comment on D is, well, it's a dual comment on D and F. I don't mean to jump ahead, but we have a provision of the contract that includes printing and providing the contract. We make it available electronically. It's on the website. We're not going to be able to agree to printing additional copies to post or various points around the building. We would expect that PAT is going to brief their members on what the contract says, what it means, and we've got our language around distribution. And from there, we're unwilling to put additional requirements in the contract around what we're going to post where and when. So for all of those are the reasons generally that we're not willing to agree to the language in subsection D at this time. Moving on to subsection E. Again, we understand the interest here. I signed up to teach a math class, and now you're pulling me and assigning me to teach a humanities class I'm not comfortable in, as I think one sort of example you gave. We understand that interest, and we're working through, again, they may be extreme examples, but they're examples that this language would allow that would exacerbate real problems we have that we're facing right now. And so that's the reason that these are the reasons we're not going to be willing to agree to proposed language in subsection E at this time in your proposal. And I mean, the one example we came up with is if someone accepts a substitute educator position as an instructional specialist, and then there's a last minute cancellation or something in another job that's available that educator may be qualified to fill. And under your language, they could refuse that. And we could have, we could have a situation where there are 2 educators in one room and 0 in another, and we're scrambling to fill that other room. And
well, none of our people, they may be on both substitute lists, but we only represent people who are substituting for professional educators, not for para educators or educational assistants.
did I get my?
Are you?
I must have gotten my example wrong. Can someone from my
No,
team
that's what I just,
correct me?
and I don't mean that in any sort, just like,
No,
I understand the example. It might be a dual, say, for example, there is like an IB history language arts class, and you have 2 professional educators in the same room at the same time for a given period, I think is what you're, to get, like, just to clarify, but yeah, they would not be filling in for an aide and then being asked to cover somewhere else as a teacher.
Yeah, and
Chris, I think you were thinking of maybe an instructional specialist role.
yes. Is that correct or wrong?
Are you asking
An
me?
instructional specialist is an educator role that that substitutes might fill for.
Might,
Yeah.
yes. Okay.
Thanks.
And both D and E, buildings that do this, substitutes are going to tend not to go back. And, that's a problem you want to address, is not having buildings that substitutes want to avoid.
I hear you. I mean, Greg, your prior point is well taken. Mark, you making that point is well taken. And this for me gets to some of my philosophical challenges with bargaining this contract and working with this group is we can't direct the work. I mean, we can direct the work once you're here, but we can't, there's no mechanism in the contract to say we're entirely at the pleasure of whether or not these substitute educators choose to come fill the roles. And so on one hand, we need to build in a number of incentives and flexibility to try to get folks to take the jobs and avoid making subs not like a particular school. So we end up with low fill rates and all of these challenges. On the other hand, we need to try to find some balance of on the management side. I was about to say management rights. I don't really mean it in the labor sense.
No,
but
I
just
know what you, no, I guess, yeah, right.
In the sense of how can we direct the work to fill these problems? And so I'm saying this as the philosophical problem, not the solution. And that's why I think we're going to have some challenges and some hurdles to overcome in bargaining this contract, because I can share with you the district is taking a very hard look at how to address these issues. And we're gonna have to work it out, because there's real tension there that's resulting in real problems with jobs going unfilled.
Mm-hmm.
And I just want to bring one more item to your attention. When I'm in a classroom, the reason that I'm here, I think you all know what's going on with me just being able to be in the classroom that I'm in this morning. I promised the teacher that I would teach the first class and he would have a colleague teach the second class, right? I consider myself working for the instructor and for the students, right? So when you thwart a substitute who has high integrity of doing the job of working for the instructor and the students, that's when we decide that we shouldn't go to that building. We'd rather disappoint the instructor all the time and say, sorry, I can't sub for you because of what happens in your building, than be subjected to having to disappoint the teacher who's actually my boss and the students who are actually my bosses. So I want you to think of it that way.
Okay, I can think of it that way, and I appreciate that perspective, Greg. That's what I would consider.
Right,
I
and these are
think it's getting at,
They're
What Greg
conflicting
is getting at is
priorities.
this, yeah, it's the educator who selects the substitute.
The
And,
district
know,
writes the
it's-
check. I'm sorry. That's
I understand. We
a
get
little
that.
rude, and I'm throwing it out there, but you know,
Yeah.
And I
I'm
mean,
the
I think
management lawyer. You got to
even
know I'm going to say that. So
Yes, we got you.
even as we step back, I totally hear you, Greg, about the personal commitments that you make and the relationships that you form as a substitute, you know, who it is that you're interacting with. There's a reason, though, that organizations have supervisors, and it's because there has to be people who take a bird's eye view, right? I mean, some students might have higher needs than other students. Some students might be able to be more successful with less resources or a less skilled substitute than other students might. And so I hear what you're saying about not wanting to let people down and those particular students down. And there has to be a way that we can get that lens at that higher bird's eye view so that we're looking at it from all of our students' perspectives.
and I would add to what Lisa said, to all of our substitute educators' perspectives. You know, one interest I'm hearing you express, Greg, and I think it's important. I mean, especially for me being relatively new to this, just to keep in mind is that you and I think the other two educators on your team are well established with the district. You're well established with the regular educator community. You've built rapport. You have these solid relationships where I might be inserting facts here, but my guess is that the three of you may be at a point that you're able to sort of pick and choose the work you want to do. And we also need to look at it through the lens of new folks to the district. Some of the folks who are working this as a part-time job, who don't have those relationships built and established, and who are, I just want to keep those interests in mind as well. I think is really the only point in comment to that.
I think we can call this a success when we've successfully balanced these two vital interests.
So I want to respect what Lisa said is, you know, supervisors have the higher purposes in mind. Totally true. But want to point out what's not considered improper under the current contract. The administrator needs a PE teacher, but no one takes a PE job. I don't know why. Perhaps that could be the case. Hey, let's post it as a math job. And then when they get here, we'll make it a PE job. Now, I'm not sure anyone does that, but that's the kind of thing we're asking to be improper.
And I think maybe, although Steve Dyke suppose that's a possibility, I don't know of any circumstance like that either, but the other one would be there's a PE job and a math job. The person accepts the math job, they get to the school says, we want you to do PE. The substitute says, I'm not comfortable doing that, I won't take that position. You now have two unfilled positions in the building. And that has happened.
Or to take that math and PE job again, the sub takes the math job, the PE job is unfilled, and an administrator has to cover one of them. The administrator should not be able to say, hey, I'll cover the math job. The administrator should take the open job.
So we understand that it's a major issue for the district. When we propose this, we wouldn't be proposing it if it wasn't of significant concern to our members that this happens. You know, I think we both understand each other at this point. Unless you have other things you want to add.
I don't have anything to add.
Okay.
Yeah, let's go on.
On insurance, the only comment we have at this time is on subsection B. We appreciate this creative thought around real incentives that we think will draw employees to our district and encourage them to help us fill jobs and fix this issue that we're facing. So we can't agree to that at this particular time. That's something that would have a lot of costing and budgetary impacts that we would need to work through to fully understand. And additionally, we're open to incentives. This contract has incentives in it. You're going to see proposals from us focused on some of those incentives. You've already made some incentive proposals that we find very interesting and we're evaluating. This is a unique one, and we appreciate the thought process here. This is going to take more work on our end. And where I was going to go with the incentive thing too is it's hard to predict if incentives are going to work, right? And this one particularly is one that we're going to have to spend some time thinking about around. Is this category of educator, I'll leave it at that. Will it work? Will the money spent work to fill the alternate goal? And I think we both understand that. And it's something that I think we can collaborate on to try to find real solutions. Other than that, we don't have any other comments on the insurance piece at this time.
Could you go back up and
Excuse me, please.
Stop right there. Well, I just want to see what that highlight, farther down. Yeah, what is this paragraph here? I just don't want to skip through it without seeing what it was. Oh, yeah. Did you have any comment on that one?
Nothing additional from the last time.
Okay. Just to give you an idea, you probably have noticed what we did with the section 12B. You don't have to go back up. We picked 133 days because 135 days is what's counted as a full year under the other contract.
Thanks
They're
for that,
190.
John. Thank you. We were wondering that, and I forgot to ask, so I'm glad you shared that.
That's okay. I just wanted, I figured, yeah, I didn't want to have it hidden. I probably should have made it clear when I was making the proposal originally, and it dawned on me. I thought to myself, I don't know if I talked about this. So 135 days counts as a full year for an educator, whether they're full-time or half-time, under the regular PAT contract. And that's 70% of the year. 192 days, 135, 70, 0.9 or something like that. And so we said, well, there are 177 days for students, which are the number of days, those are the number of days that a substitute educator can work. So what's 70%? That's the only thing that we just broke it out that way.
70% of what would constitute of everyday worked for students.
Yeah.
Okay. I appreciate that. I should have asked because we had that question. It's good.
I think it was because, isn't it like a 70%, somebody who's a 0.7 employee gets the full insurance?
0.75, I think. Oh, yeah, it's 0.75. Yes, I'm sorry.
Okay, something like that.
0.75, yes.
Ditto on D on incentive. We want to piece together all the potential incentives, budget them out, try to understand if we think they'll work, and then try to move forward in this contract with real incentives that we think will help fix fill rate issues, complete our jobs, and help provide fair compensation and benefits for substitute educators. So we appreciate the creative thought here. We're not agreeing to these because this is something that we want to bring our ideas forward to, match them up with yours, and then let's try to talk through them in terms of what the overall economic impact on the district that this contract will have. I didn't say that very clearly. Sure. I think you understand.
No, I understand what you're saying, though. Yes, you're not against the concept of incentives, but you're not. It's also not clear yet what the impact would be financially, and the district has both concerns. We hear you loud and clear.
And same with incentive pay. You're sort of reading our mind on this one. This is one that we're taking a close look at as well. And then finally,
we're using, by the way, on the incentive pay one, that we try to indicate with the note that we're not wedded to the concept of incentive pay. The history of the incentive pay was that when the district was trying to address, and Mark, you were part of this meeting, years ago, 7 years ago, 6 years ago, the issue of low fill rates. The district and the association put together a list of, I'm making this number up, but I believe it was about 16 or so different ideas on what could be done. And Sean Murray was part of those meetings, and you can probably find it in a file somewhere, but we met And we talked about it a few times, and then the district said, well, let's try the simplest thing, that if, we'll do this seems the simplest way to do it. We'll try this first. And at least anecdotally, the $5 was not addressing the fill rate need. So we had some comments from some educators saying, the $5 is just not enough to change my mind. So, which is why we did it. But also, we're really concerned. It's E below. It's the note in E below that we'd like to really discuss and explore with you.
Yes. Only thing I'd add to what you just said, John, is we will be looking, when we're matching up these incentive proposals and bringing some of ours forward, to target them for the historically underserved schools. Those are
Sure.
where the need is most acute. And we
We
would like to try to, we're not as interested in incentives for schools that have high fill rates for jobs. So
I understand.
yeah, and this one, you're right, E is particularly fashioned to address that issue. So we appreciate it, that we're taking that one to heart, and something we'll be looking at. And yeah, as far as the note, we're not prepared right now to launch into a full discussion, but we are fully prepared to discuss that. We agree that maybe having frameworks for discussion may help move this along, rather than exchanging, very specific written proposals. As you know, there's a zone schools concept that's being discussed in the regularly employed teacher contract negotiations. There's going to be we see a lot of potential for overlap here with the subcontract within that concept and with what you flagged here. So we're open to this. I think that it's a great idea to target specific schools and to include some sort of ability to assign or direct to help fill this acute need. And there are a couple other separate program type ideas that we're going to be excited to bring forward. We're not there yet to do it today, but we'll be excited to bring those forward too, to try to really advance the same goal in parallel with a program of something like this type.
We're wide open to it, and we're really interested in hearing it. It was, I was surprised to find that our initial concept, as we explained it, you never know who's going to listen to what, but we had some of our regular educators listen to the YouTube of The Last Bargain, and word got around, not a lot, but a little bit. And this is in fact of interest to the regular educator also. Not that we're sold solely on that idea that we floated you, but the idea of having ways to address this. So we are wide open to this. We think it's good for district, substitute educator, and regularly employed educator as well. And obviously that would mean the kids.
All right, well, thank you. We don't have a comment on term right now. I mean, we're looking to negotiate a full contract. We're not asking at this point for any sort of rollover or 10-year deal, but we'll take a look at term as we're putting together our comprehensive proposals.
Okay.
So that concludes our comments on your initial proposal. We still have some time left. Like I said, I need just a little bit more time with my team to review our proposals and put the finishing touches on them. I think we can get that done in a reasonable time to then come back and deliver them and at least give a cursory overview of what we're sending at this time. But we would need to ask for some caucus time to make that happen.
Sure.
Are you all open to that?
Yes.
Okay. Can we tentatively say 12:20? I have a feeling it might end up being 12:30, but if we work through it quickly, maybe let's count on 12:30, and John, I'll be in touch if we need a little more time than that.
That's absolutely fine. We'll go to our caucus room that we met in this morning and wait for your text.
All right. Thanks a lot, John. And thank you all.
You got it. Thank you.
Thanks.
John, did I stop my screen share here?
Yes,